Okay, I believe we're live.
Thank you. We welcome you to the March 3rd, 2021 settings of Seventh Court of Appeals presented through the Zoom video. We will go on and call the docket this morning, and I want to thank the lawyers in the case before us appearing by Zoom. Hopefully, if you've heard the governor's announcements recently, things may be changing and we may have a little bit more latitude, and apparently that's something the Supreme Court is considering, granting a little bit more latitude and in-person presentation. So we look forward to that day. With that said, we'll go on and call the docket, and I'm not going to ask for announcements because I'm going to presume that since you're here, you're ready to proceed. So we'll go on and call the first case we have for this morning, 07-20-00131-CV, Jessica Pena versus Clint, Harp, and Harp Holding LC. And Ms. McPeters, I see that you're here, and you got the floor.
Thank you, Your Honor. May it please the court. My name is Morgan McPeters. I represent the appellant Jessica Pena, and we would ask to reserve 5 minutes for rebuttal.
Yes, ma'am.
This court should reverse the trial court's summary judgment for 3 reasons. Number 1, Harp Holdings failed to meet its burden to conclusively establish every element of its affirmative defense that a release agreement between Airbnb and Ms. Pena should likewise apply to Ms. Pena's claims against it. Number 2, fact issues as to whether the dangerous condition of the staircase at issue in this case were open and obvious remain that preclude summary judgment. And alternatively, the necessary use exception applies, which would bar summary judgment on that basis. And third, Pena demonstrated that there is at least a fact issue as to each of the challenged elements in Harp Holdings' no evidence motion for summary judgment as to her premises liability claims. Specifically, she demonstrated that there's a fact issue as to whether the condition of the stairs posed an unreasonable risk of harm. And second, whether Harp Holdings knew or should have known of that dangerous condition. So I'm going to turn first to this question of the affirmative defense of release. So a post-injury release agreement is an affirmative defense. And here Harp Holdings was the movant. As the movant, they had the burden to conclusively establish every single element of that affirmative defense. And of course, the burden to respond and demonstrate a fact issue never shifts unless and until they meet that initial burden. A release is a contract. Therefore, courts apply the same principles of contract construction to these types of agreements. And generally, unless an agreement is ambiguous on its face, the courts are limited to the 4 corners of that document. And we are trying to ascertain what were the parties intending by this agreement. So here, in this context, Harp Holdings, in order to rely on this Airbnb release, they had to demonstrate first all of the elements of an enforceable contract, all those elements that we know: offer, acceptance, mutual assent, execution and delivery with an intent to be mutually bound, and consideration. But perhaps more importantly, and specific to this case, they had to also demonstrate that they were a party to that agreement, or if not a named party, a third-party beneficiary. So Harp Holdings failed to carry its burden to establish any of these elements. Specifically in the trial court, they never addressed the elements of an enforceable contract. They sort of just presumed that this was, in fact, an enforceable agreement and then just moved on from there. So,
was there any, counsel, is there any question that the agreement is enforceable? I'm not talking about who the parties are, but is anybody contending that the agreement, the release, is unenforceable?
I don't think there's necessarily a dispute as to whether it's enforceable, but what's important to note is that as the movant in a traditional summary judgment motion, their motion needs to stand on its own regardless of any responsive matters. And so the fact that they never even attempted to argue these issues in the trial court is problematic. But I think that the bigger issue, and what gets to Your Honor's point, perhaps, is that they simply never overcame the presumption that they are not a party to this contract and that it does not apply to them.
Well, the agreement does the agreement have a paragraph that says who is releasing who?
Yes, Your Honor. And we have provided, just for the court's convenience, exhibits that have the contract pulled out. That's tab A of what we filed with the court. So paragraph 4 is where we talk about who this release pertains to. And that language in paragraph 4 states that the release applies to Airbnb and all officers, directors, employees, contractors, and agents of Airbnb. It goes further on in that paragraph and states that it applies to claims and causes of action whatsoever that I may have or which may arise against Airbnb. And then there's additional language talking about injuries arising from this particular Airbnb reservation. And altogether, the paragraph and the sentence rather that talks about claims against Airbnb, those are defined as host/guest actions. So that's a defined term. And there's several things I need to point out here. Number one, Harp Holdings, it's undisputed, they are not named by name anywhere in this agreement. Number two, they never argued that they are part of this exhaustive list in paragraph 4 of the parties who this release pertains to. They never once argued that they are somehow in this category of Airbnb and all officers, directors, employees, contractors, and agents of Airbnb.
So counsel, I'm sorry, let me ask you a question then related to that. The question of whether they are, Harp is a contractor then isn't defined in the agreement, but you're saying that at summary judgment, the defendant also didn't move for summary judgment on the grounds of arguing it was a contractor?
That's correct, Your Honor. They simply never asserted that as a basis for why this applies, why this agreement should apply to them or benefit them. There's nothing in the record where they have argued that they fall under any of those terms. Instead, their focus appears to be on the types of claims generally that might be covered by this. But again, the language of the contract makes clear that what we're talking about is claims against Airbnb. And it's the fact that those claims are defined as host/guest actions does not mean necessarily as a matter of law that this release was intended to benefit them. And what's crucial here is that the Texas Supreme Court has said time and time again that we cannot presume intent for a third-party beneficiary in a contract. We presume that parties intend to contract only for themselves. So there's a presumption at play here that has to be overcome. And if there's any doubt as to whether or not a third-party beneficiary who's not named in a release is supposed to benefit from that contract and was originally intended to do so, we have to deny that claim. And here that would mean that there's a fact issue at the very least, and that a fact finder should be entitled to resolve this question.
Ms. McPeters, what is the basis of your liability as to holding? You're claiming that they're the owner of the property, is that correct?
Yes, Your Honor.
And that Airbnb is some sort of leasing agency. Is that your theory?
It's my understanding Airbnb acts similar to a broker.
Okay. And then the liability is by virtue of their arrangement, Airbnb's arrangement with host. I'm trying to figure out who a host is.
Well, Your Honor,
is the host the property owner?
the term host is not defined within the terms of this release agreement. However, the basis for liability against Harp Holdings is their status as the premises owner and Ms. Pena's status as an invitee on that property. And I think there's certainly no dispute as to those facts, that they are the premises owner and Ms. Pena is an invitee. So all of this really gets to the question of, should Harp Holdings be entitled to rely on an agreement between other parties that does not evidence any intent to benefit?
I'm trying to establish who's the host.
I believe that I don't think there's any real dispute here that Harp Holdings is the host in this context, but nothing in.
May I interrupt?
Yes, Your Honor.
Is the term host a definition used in the agreement between Airbnb and whoever owns the home?
Well, Your Honor, that's simply not in the record. There is no evidence to support that position one way or the other. And that ultimately goes to the issue here, is that Harp Holdings had the burden to conclusively establish that this applies to them, and they just never even really attempted to do so. They just said, in a sense, this agreement talks about all claims, therefore we should fall under that term. But the courts.
Is there anything in the record that describes the relationship between Airbnb and the entity or person who owns the property?
I don't believe so, Your Honor. I don't believe that they offered anything to that effect. So I'd like to, one other thing I want to point out about the face of the contract within the four corners of it is the fact that when we are interpreting contractual provisions, we have to review the document as a whole and interpret the provisions in harmony with one another such that some aren't rendered superfluous or meaningless. So one important thing to note here is in paragraph 5 of the release, there is a subrogation provision whereby Ms. Pena agreed to reimburse Airbnb if she recovered for claims related to this property reservation from other parties. And the release specifically contemplates in this paragraph that she retained claims against a host, because it specifically talks about recovery from a host. And so if the court is to find that conclusively as a matter of law, Harp Holdings was a third-party beneficiary of this release and that Ms. Pena released all of her claims against Harp Holdings, it would render this provision meaningless, which would be a violation of the contractual interpretation rules. So with that all being said, the summary judgment, traditional summary judgment cannot be granted on this basis and should be reversed. I want to turn now to the next element of their traditional motion for summary judgment, which is the question of open and obvious. So in determining whether—
Counsel, I don't mean to interrupt you. I just want to make sure I understand your position. If we hold against you on the settlement agreement, we hold that there was a release and waiver, do the issues on whether there was an open and obvious problem, are they relevant at that point, or did they go away because the settlement agreement would be enforced?
If the court were to find that the release agreement was enforceable and intended to release Ms. Pena's claims against Harp Holdings, I believe that would dispose of the other issues as well. However, if there's a fact issue on that basis, the court would need to move on to determining whether there were any other bases to support the trial court summary judgment, because the summary judgment order is not specific as to the grounds.
Right. Okay.
So as to the question of open and obvious, I have again included in our exhibit some photographs of this staircase. You can see from the photographs and from our briefing that the stairs are painted black. They are wooden. They curve in a strange way at a 90-degree angle. There is no hand railing on the right side. There is a hand railing on the left, but once you get down into the staircase, you learn that the hand railing on the left is actually very wide and can't really be gripped. And then additionally, the area where Ms. Pena fell, which if you look at tab C of the exhibits we filed, this is a photograph, and I've got it in black and white. It's a little harder to see, but also the same photograph in color. She has circled in her deposition the area where she fell. And so at that spot, you see those pie-shaped stairs And you see also that there is a big corner post where the handrail is interrupted entirely, and there's nothing on either side to grab. And then beyond that, in tab D, you can see also that just past that corner post, the handrail drops way down. So it's not even that the handrail wraps around and is immediately accessible at the same height. So just wanted to provide that as some context as we discuss whether or not the dangers posed by this staircase were open and obvious. So,
you just mentioned there was a deposition for, correct?
Yes, Your Honor.
In that deposition, was she asked whether or not she saw the pie slice shaped steps before she stepped on them?
She was, Your Honor, and I believe at the clerk's record, page 794, she was asked about that, and she testified that she did not notice that the treads were pie-shaped at that corner. And additionally, she talks about in her deposition that she'd never used stairs like this ever before. She was encountering this particular staircase for the first time ever while descending it, because there were two staircases in this house. She had gone upstairs the first time the back way, and for the first time ever, she's encountering this staircase to go downstairs. She also testifies that she didn't think that these stairs were dangerous. She didn't think that there was anything so different about them that that she would fall or that they would somehow be unsafe. Otherwise, she would not have gone down them. And that's, again, at that same page, 794 of her deposition. So,
quick question. Did she describe, I guess, in the pictures, or is there anything in the record to state whether or not the colored pictures of the staircases that you have are lit the same way in the picture as they were when she was descending them?
well, Your Honor, we know that she was descending the stairs sometime between 10 p.m. and midnight. Right. And these photographs, I'm trying to recall if there was a specific line of questioning as to whether the lighting was exact. I don't know that there was, but I think it's plain from the photos that these photos are taken in a daylight setting, and that at the time she is falling down them at night. And she does testify that it was dark on the stairs, that it was a dark area. We have our expert, Mr. Nelson, who is a professional engineer and a safety expert. He testifies that while it may have been visible to her that the stairs were black and that there appeared to not be a railing on the right side, but she could not, and an average person, a reasonable person, could not have anticipated the dangerous condition posed by the combination of all the things that were wrong with this staircase. That she could not have anticipated that the color of the stairs would make it difficult for a person to discern one step from the other. And she falls at that pie-shaped weird corner where the stairs are different treads, different widths and heights. He also talks in his testimony about how she could not have anticipated, as she began to use the stairs, that the condition of the left handrail is likewise unreasonably dangerous. You can see that there's a handrail there, but as an average person approaching this staircase, you have no way of knowing that the handrail is too large so as to not properly allow someone to safely grip it for descending the stairs. He also talks about how risks of staircase generally are less apparent when you are descending them for the first time, that when you're climbing a staircase, you can better perceive what the risks ahead of you are. But as a person using it for the first time while going down, that's less apparent. Ms. Pena also could not have anticipated that there was no railing whatsoever at that corner post area. So while she may have seen, okay, there's no handrail on the right, she could not have anticipated that at the point where she fell at that corner pie-shaped area, all there is a large post with kind of a round ornamental thing on top. And that at that spot, there is nothing to grab onto. The handrail is interrupted by the post. There's nothing on the wall. And so all of these conditions combined together in a way that it would not have been open and obvious to Ms. Pena or to a reasonable person approaching these stairs precisely what the nature and full extent of the danger was. And so for that reason, their summary judgment motion on this basis also fails. Alternatively, we've set forth in our briefing that the necessary use applies. So if the condition was in fact open and obvious, or if she did fully perceive the dangerous nature of the condition, that Harp Holdings nonetheless owed a duty because because she simply had no other reasonable choice. They should have anticipated that she would have to encounter these stairs. And the reason
what the test is for necessary use, no other reasonable choice.
So the test is that it was necessary that the invitee use the unreasonably dangerous premises, and that the owner should have anticipated that the invitee would be unable to avoid. And the Texas.
Do you have any? Okay, you're going to say that who defined necessary?
Yes, Your Honor. So in Parker versus Highland Park, which is a Texas Supreme Court case, 565 Southwest 2nd at page 515 of that opinion, the court talks about how we're looking at whether an invitee may have reasonably been expected
What
to
did
choose.
the Supreme Court say about necessary? How did they define it?
So it's a question of whether they would reasonably be expected to choose to use that premises.
Okay.
And I see that I'm out of time, so I will, unless there's any further questions, I'll reserve the rest of my time for rebuttal. Thank you.
Judge Bertle, Judge Doss?
Good, thank you.
Thank you.
Thank you. Mr. Beliveau?
May it please the court, Ian Beliveau for appellees Clint, Harp, and Harp Holdings. I'll start that I'll agree with, to an extent, with what Ms. McFeeters said, that the release agreement that was entered into is not a model of clarity. I think everyone sitting here, if they had actually been the ones that wrote it, they would have probably made it a little bit more clear and along the lines of our standard form releases that we use every day in litigation. And I'll agree with Ms. McFeeters that Clint Harp's name and Harp Holdings' name do not appear anywhere in the release. But that does not, under Texas law, mean that they are not afforded the protections of the release. In the Duncan versus Cessna aircraft case, the Supreme Court of Texas said, a tortfeasor can claim the protection of release if he is referred to with such descriptive particularity that his connection with the tortious event is not in doubt.
Where are you described or referred to with such clarity in your view?
So that's a good question, Your Honor. So as one of the questions that was being posed to Ms. McFeeters, I don't think anyone has ever really questioned that Mr. Harp and Harp Holdings were a host. And as she stated, there is no contract in the agreement setting forth the relationship between Airbnb and Mr. Harp or Harp Holdings, but I think it's just a presumption that everyone has always operated on. That said, as Ms. McFeeters told the court, the release defines acts or omissions by host, guest, or other party during a stay at the accommodation, which is the subject of this Airbnb payment agreement, as quote unquote host guest actions. The following sentence says, I understand and agree that this release and obligation to hold harmless applies to all claims I may have related to such host guest actions, whether such claims are now known or unknown, or which may become known in the future. And it goes on to state more. So here, being that Harp, and I'm just going to generally call it Harp, is a host, someone could easily look at this agreement and say that Ms. Pena released all claims she had related to host guest actions.
Counsel, let me ask you a question that was posed or that was raised by the other side just a minute ago. If we look at the subrogation paragraph, the subrogation paragraph at least indicates or suggests that there may be other claims that have not been litigated, and that Airbnb has the opportunity to come back and obtain some of that money from those issues. Does that raise a conflict in the paragraph with what you have by saying maybe the claim is certainly covered by what you're talking about, but the parties aren't clear because we have this issue pertaining to the host that's still lingering out there that may be subject to a subrogation agreement?
Okay, and Justice Doss, I'll say that this is again an area where this agreement is not a model of clarity, but I don't think that paragraph 5 is the subrogation provision, really. If you look at paragraph 2
Right.
of the agreement, I think that is more what I'll call a subrogation, what I would think of as a subrogation provision. And that paragraph says, I hereby assign to Airbnb any rights I may have to recover the amount paid by Airbnb to me from the applicable host, guest, or any other party that may be financially responsible for the payment approved by Airbnb. Now, it wasn't raised, so I'm not going to get into it, but I think that, that paragraph raises a whole nother question as to whether or not there are any live claims that she may have. But I think that is more the subrogation provision. And how does that jive with paragraph 5? It's hard to say. Like I said, this document is not a model of clarity, but if you look at the totality of paragraph 4, if you accept Ms. Pena's interpretation of the agreement that it only applies to Airbnb and its officers, directors, employees, contractors, and agents, then it renders that entire bottom half to third of that paragraph superfluous, because there's no need for anything saying that she's releasing all claims related to all host guest actions.
Can you assign a claim that you've released?
I think so, because I think it applies in the subrogation context.
How can the person to whom you assign it recover if it's been released? Doesn't the assignee get the rights to the extent that the assigner had?
I would agree that if something is released, it cannot be assigned, and that's something that my firm runs across a fair amount, because we do subrogation work, and have run into situations where there have been releases before we get involved.
Well, again, with regard to paragraph 2, if that agreement released your client, what rights were assigned to Airbnb?
And that's true. Then the argument would really be none. And I'll tell you that similar language is included in the hundreds, if not thousands, of releases that I have prepared over my 15, 16 years as a defense attorney. And I've honestly, the way I've always interpreted it is that that's more of a catch-all provision, so that to the extent any conceivable claims that may be held by someone else, it's more an assignment as a catch-all, so that someone can never come back and bring claims again that may have somehow fallen outside of the scope of the release that was drawn up. But again, Your Honor, I'm not the one that drafted this. My firm didn't draft it. I can only play the hand I'm dealt. So.
Oh, I understand that. And that happens a lot. With regard to paragraph 4, it reminds me of some of those real old court opinions where you have one sentence paragraph that covers half the page. But the first sentence in paragraph 4, can that be read as describing two things: who's being released and for what they're being released? Who being Airbnb?
You're saying that first sentence that takes up about half the paragraph?
Exactly. The one that you got to go, okay, hold on. My English teacher would have gotten really mad at me if I wrote that in my thesis or whatever, my theme. But yes, that one is a reasonable reading of it, indicating who's being released and the other part of what they're being released.
I think it's our position that identifies with respect to specifically Airbnb who's released. But again, that gets back to what I was responded to Justice Doss, that if you accept Airbnb's position, it renders the whole second sentence, because I guess there's only 2 sentences in that paragraph, it renders that second and last sentence just superfluous. It may be the last, that one sentence is I understand and agree and release obligations. It renders that sentence superfluous.
Well, not necessarily if that whole paragraph is referring to who's being released.
Right. But I think it also gets back to one of their questions. I can't remember if it was Justice Doss or Justice Pirtle that posed it, as to what exactly is being released. If being
And
that
that's
this
what
is
I'm getting at. It's talking about who's being released, and it expressly says Airbnb. Now, I understand you're saying, but you got to read it in the implication. It includes the host too.
well, yeah, because it defines host guest actions as any is from acts or omissions by a host or guest. And then it goes on to state, I'm releasing that this release applies to all claims I have related to such host guest actions, which would, reading that would include acts or omissions by Harp Holdings. And getting to the open and obvious stuff, there are a couple of questions that the court asked Ms. McFeeters. One, Ms. Pena did testify during her deposition, and I know where it is in her deposition. I don't have an exact site to the record, and I apologize for that. But she did testify that she recognized that the pie-shaped treads at the turn were quote unquote different from the other steps. And that's on page 162 and 163 of her deposition. So she knew going down that those parts of the stairs were different. The court also asked about lighting, and Ms. Pena testified that the lighting did not play a role in her fall. And that's on pages 139 of her deposition and 170 of her deposition. So the bottom line is, whenever she started to go down the stairs, she knew that there wasn't a handrail on the right side. And I think that the pictures that have been supplied to the court and in the record clearly show that anybody could notice that there's not a railing on the right side. They show that the stairs are black. And she also testified that she knew that the steps were different in that area. And there is no evidence in the record as to the exact mechanism of her fall. She did testify that she did not slip. She just said that she went and put her foot down and something felt different. That's all she said. But I also, in looking at the pictures and going on what Ms. Pena said about noticing that those parts of the narrow end of the pie was shaped differently, it doesn't take a physicist or mathematician to realize that if you step over about a foot or two, there's a lot more area for your foot to support your foot.
And let me ask a question about that. I was thinking about the same thing. Suppose she had wanted to do that. She'd wanted to avoid the narrow pie-shaped portion and had decided she wanted to step to the wider part of the tread over on the outside, so to speak, of the stairwell. There's not a handrail over on that side for her to support her weight. What's your response to the appellant's argument that that at least suggested that if there had been a handrail on that side, she would have been able to go down that side of the stairs possibly safely, but she couldn't do that because there wasn't a handrail there?
Personally, I don't think you need a handrail to be able to go downstairs. I think about all the times I go downstairs every day coming to the office, and very rarely do I ever put my hand on a handrail.
Are you the standard by which everybody else should be measured?
What was that, Your Honor?
Are you the standard by which everybody else should be measured then?
So my girlfriend would say I'm not a reasonable person, but it's a reasonable person standard. But I think if she wanted a way to go down the stairs and needed to balance herself, she could put her hand on the wall to steady herself if that was necessary. But there's no evidence in the record that she even needed a handrail or was utilizing the handrail to go down the stairs as it was.
Does the expert report indicate one way or another an opinion about whether the handrail was required? or which necessary to meet the standard of care?
I think that if my recollection of it is correct, Your Honor, their expert said that 2 handrails would have been needed. But there's case law out there that says the absence of handrails is an open and obvious defect. And I think he says the handrail that's on the left is a little too big. I think that brings in a whole host of other issues that aren't before the court. But the bottom line is Miss Pena knew and was aware of these conditions as she went down the stairs. And while they claim
is if you look at the pictures there and the exhibits that she's attended for oral argument, you can see the black stairwell and steps. Is painting, in your view, a stairwell and steps black somewhat? Does it cause all the steps to kind of merge and inhibits differentiation between the different steps?
When I'm looking at a picture right now, Your Honor, that's in our summary judgment, that's in black and white, and I can see where every step begins and ends. The photograph that was an exhibit at Miss Pena's deposition, and
Are you looking at those steps from top down or from bottom up?
The picture that's in Miss Pena's deposition is the same one that Miss McFeeters supplied, where Miss Pena circled where she fell on the pot, where she had stepped on the pie shape. So that's looking down.
That's in tab C of your handout.
Yes,
I believe of appellant's handout.
Yes, Your Honor. And in looking at that, you can see where every step begins and ends. And let's not forget that, I mean, Mr. Harp and his family lived in this home for around 2 years and never had an incident on these stairwells, and that includes with his mother-in-law and his children. Moving on to the necessary use thing, our first point on this is that Miss Pena never pleaded this in the trial court. They've asserted in their reply that they don't have to. That's not my understanding of Rule 94, the Texas Rules of Civil Procedure. Harp Holdings pled open and obvious. To me, that's no different than if I pleaded statute of limitations. If somebody thinks that the discovery rule or fraudulent concealment is applicable to my affirmative defense of limitations, it is incumbent upon them to plead those in an effort to defeat limitations. Here, it's necessary for Ms. Pena to have pleaded necessary use.
Is open and obvious a question of fact or a question of law?
It's a question of law, Your Honor. It goes to duty. I believe that's the I want to say it's either the Whitworth or Woolworth case. I believe it's a 1976 case. I want to say somewhere around there from the Supreme Court of Texas, because whether it's open and obvious goes directly to duty, because if a condition is open and obvious, there is no duty owed.
So the court determines whether or not it's open and obvious. We look at those pictures and say, yeah, it's open and obvious.
Correct. You can determine whether or not, because open, I mean, and that's another point, is on open and obvious, they say it's a subjective standard. That's just not the law in the state of Texas. If open and obvious was a subjective standard, every plaintiff's attorney could coach their clients to state they didn't see it. And so they could be up at the Paladera Canyon and walk off a cliff and say, well, I never saw that the canyon was there, when it's the second biggest canyon in the United States behind the Grand Canyon. I mean, it doesn't make sense. That's why the case law says it's readily observable or known to the plaintiff. It's not just subjective. If it's objectively so observable, then it's open and obvious. On the necessary use, even if it applied, Ms. Pena didn't establish either element. She didn't establish that it was necessary for her to use these stairs. She testified that she'd used the rear staircase early in the day, and the only reason she didn't use it at this time is because it would have been a quote-unquote inconvenience, because there were some girls in that room and had the door closed. There's no testimony that the door was locked. There's no testimony that she couldn't have walked through it. She just made the decision to use those stairs to go down. The other part of that test is that they had to establish that Mr. Harp should have known that she had no choice but to go down those stairs. Well, they didn't establish that. And even if you look at the necessary use, what exactly is the dangerous condition they're complaining about? They've testified to 3. Let's assume it's the pie-shaped part of the stairs. Well, that part of the stairs, if you want to look at another necessary use case, is the Nethery case that we cited. And that's a situation where there was ice on a driveway, but it was only iced up on part of it. And the gentleman walked across the iced up part. Well, Miss Pena could have walked on the part of his treads that she knew was bigger. She made the decision not to. So if the pie-shaped narrow part is the dangerous condition, they haven't really made complaints about the rest of the stairs. It wasn't necessary for her to use that portion of the stairs.
Quick question. Is there anything in the record regarding Ms. Pena's physical condition prior to the fall?
Not that I'm aware of, Your Honor. I did not. You talking about did she have any impairment in her gait or anything, or hip issues or something like that?
Dizziness or things like that too.
I'm not aware of anything off the top of my head. I didn't see that. And then on the no evidence summary judgment, the same thing. They didn't establish that there was a condition that posed an unreasonable risk of harm, and they surely didn't establish that Mr. Harp knew of anything. If anything, he lived in the home for 2+ years incident-free with nothing ever happening. If there's going to be some knowledge imparted, you would have thought it would have been then due to prior incidents, including his children using the stairs. I see I'm out of time, so if there are any other questions, I'll go.
Judge Pirtle, Judge Doss, questions? Thank you, counsel.
Thank you, Your Honor.
Rebuttal, Ms. McPeter.
Thank you, Your Honor. May it please the court. Just a couple points. Counsel for Harp Holdings has acknowledged that the release is not a model of clarity, in his words. And to me, that shows why there is a fact question here. Texas case law is clear that if there's a question of the party's intent, if we can't tell one way or the other from the language on the 4 corners of the document, the third-party beneficiary claim must fail. So there is a fact question here. And in fact, I want to address briefly this argument that the second sentence of paragraph 4 would be rendered superfluous if Ms. Pena's interpretation is accepted. But that is not the case, because that term, host/guest actions, which Harp Holdings' argument depends upon, is in fact defined in that first sentence to mean claims against Airbnb. That entire first sentence defines who is being released and what is being released. And it evidences that Ms. Pena never intended to release claims against Harp Holdings. Therefore, there is at least a fact question there. As to the open and obvious issue,
Counsel, do you think painting stairs black is inherently dangerous?
Well, Your Honor, our expert testified that the paint color choice made by Mr. Harp made it difficult for a person to discern one step from the other.
Did he explain why black made it difficult? Why the color black itself made it difficult?
Well, I think you can tell from the photos that all the steps kind of run together. And as you're approaching these stairs, you can't really discern them. And then I think as you're descending them at night, the color black makes it so you can't discern where one begins and the next step ends. Or I may have said that backwards, but he does talk about that in his affidavit and in his certificate of merit, that specifically the color is a problem here. And
just open and obvious, if the color is a problem, is there anything in the record to indicate that she knew the stairs were black before she descended them?
She does say that she saw that the stairs were black. However, Mr. Nelson, the expert in safety and engineering, testifies that a person could not, an objective person approaching these stairs, an average person could not have anticipated that particular issue until they were on them. And so that's some evidence in the record to demonstrate that there is a fact question here. And while an open and obvious question is a question of duty, courts determine the existence of a duty based on the facts and circumstances. And so we do have to still look at the evidence to determine whether there is or is not a fact question. And
Well,
here,
is there a fact question? It's pretty clear that you've given us pictures of the stairs. You've given us pictures of the triangular steps where the stairs turn 90 degrees. Isn't that what you look at in order to determine whether or not it was open and obvious? You look at the condition, and
Well,
that's pretty clear what it is.
we have to also look not just the benefit of hindsight, standing with a camera that may or may not have a flash, looking straight down. You have to consider that these stairs were being used by folks who may or may not have ever encountered those stairs because of the existence of the second staircase. Descending for the first time, as you approach that staircase, those risks are not readily discernible. So an invitee approaching that staircase to descend for the first time has no way of knowing precisely what they're about to encounter. And the case law requires that knowledge and full appreciation of the full extent of the danger. And so our expert has testified that it's not just the lack of a handrail on the right side or the color black of the stairs. It's this perfect storm of all of these conditions of these stairs that would not be readily ascertainable to a person descending them that causes this to be a dangerous condition. Last thing I want to talk about is the necessary use exception and whether or not Ms. Pena could be reasonably expected to encounter this danger. So Harp Holdings contends that it would just be a minor inconvenience to use the back staircase. However, no reasonable person would have, in a house capable of hosting at least 17 people, gone through an occupied bedroom, which was at the time occupied by 3 minor children, other people's children, to access a staircase. It's just not reasonable, and therefore the necessary use exception would apply here. I see I'm out of time. Thank you, Your Honors.
Thank you, counsel. Judge Purtle, Judge Doss, any questions?
No questions.
Well, thank you very much for your presentation and your cooperation in the presentation through Zoom. And the case is submitted, and you are excused to go, and you'll hear from us forthcoming.
Right.